fulfill the promise of an early trial she made in court on the 17th of July 2024. The march was extremely peaceful and adhered to all previously agreed agreements with the Ghana Police Service. The march culminated at the precincts of the Supreme Court. The agreement with the Ghana Police Service was for the leadership to present our petition in front of the statue of martyrs inside the premises of the Supreme Court. However, on the day, the Judicial Service delegation met with us at the main gate of the Supreme Court. We did not protest this change in plan. We complied in the interest of public peace. The Judicial Service delegation was led by a magistrate of the courts, the Registrar of the Supreme Court, the Director of Communications and his deputy, and the Chief Security Officer of the Judicial Service. Our encounter with them was cordial and respectful. The allegations of attempting to visit mayhem on the Supreme Court of Ghana made by a judge of the Supreme Court are very grave and need to be investigated. In that press encounter, several untruths were unfortunately peddled about the Families Values March by the said judge of the Supreme Court, and it is imperative that the facts are established without any doubt for the benefit of the public. As such, I will be invoking the jurisdiction of the Privileges Committee of Parliament to summon the gentleman who is a judge of the Supreme Court to the Privileges Committee of Parliament. He addressed the said press conference and he needs to substantiate a number of untruthful claims he made in his press conference. The image of Ghana must be respected, and especially at this juncture, let me reiterate that at no point in our petition to the Chief Justice did we demand, request, or even remotely suggest that the Chief Justice should rule in favor of the sponsors of the bill. We have simply asked for the Chief Justice to provide us a timetable for the early trial she promised. Our petition is premised on the actions of the Chief Justice in two cases this year, where the court swiftly issued hearing notices within hours of injunction applications being filed, and heard the cases even without a statement of defense from the respondent, the Attorney General in particular. In the Napo versus Attorney General case, the Attorney General did not even file a response, but the Chief Justice heard the injunction application and dismissed the injunction application within 24 hours. Again, in the Bernard Ahia 4 and 2 others versus the Minister for Finance and 3 others case, the injunction application to hold certain tax waivers by government pending determination of the main case was filed on Friday afternoon, 26th of July 2024. By the following Monday, the court had issued hearing notices, heard the case, and dismissed the application the next day. This was in spite of the court's own rule attached to the process by the registrar, stating that, and I quote, "A date will be fixed for hearing of the above stated application with hearing notices to the parties by the registrar upon request 20 days after service of the application on the respondents or interested parties," end of quote. In fact, lawyers for the plaintiffs in that case were compelled to argue their case on the same day. This raises fundamental questions of what the real intent is in the current cases regarding LGBTQ and the lethargy we are witnessing from the Chief Justice and her courts. Again, let me state for the records that there is a complete untruth and palpable falsehoods peddled by a Justice of the Supreme Court who addressed the media for anyone to claim that the injunction cases before the Supreme Court is not ripe for judgment. All pleadings and arguments have been made before the Supreme Court, and the Chief Justice scheduled 17th of July 2024 for her ruling. How will the CJ have scheduled a date for ruling if the cases were not ripe? Persons who ought to know better should not be engaged in peddling of factual untruths which are easily verifiable. Our judiciary must always remain above reproach. As sponsors and as members of the coalition who embarked on the Family Values March, our position remains unshaken. The Supreme Court panel, hearing the Richard Delaskai and Amanda Odoi cases, led by the Chief Justice, must be minded of the ruling of the Supreme Court in the Dr. Prince Obri Crime vs. Attorney General case, delivered on 24 July 2024. Their Lordships, Bafoboni JSE presiding, Lovelace Johnson Mrs. JSE, Amadou JSE, Kolengi JSE, Jehu JSE, Dako Asari JSE, and Ajay Frimpong JSE were emphatic on the position of our law and constitution on homosexuality in their 59-page ruling. Let me quote their conclusion in that ruling. I quote, "In conclusion, I wish to reiterate, in respect of the issue that was set down for determination in this suit, that Section 1041 of Act 29, which criminalizes non-natural carnal knowledge, does not contravene the Constitution of the Republic of Ghana. The plaintiff's conception of private morality as a ground to limit or expand the constitutional rights to privacy lacks sufficient context in the nation's constitutional architecture. Indeed, it is fundamentally poles apart from Ghanaian family values. Our constitutional provisions derive their purpose and values from our traditions, customs, and culture. Consequently, the plaintiff's action fails in its entirety." End of quote. And this is the conclusion of the 59-page judgment from the same Supreme Court of Ghana. We insist that the court, led by the Chief Justice as head of the judiciary, can, and in similar manner, which it swiftly dealt with the applications referred to, control these cases so such important law with overwhelming approval by Ghanaians is assented to invoke the jurisdiction allegations that I led a group to cause mayhem at the Supreme Court. Persons who ought to know better need to act better and will be held to higher standards of accountability. At this juncture, I will play a video that shows my encounter with the Judicial Service. I'll be serving you the raw copy of that video as well to establish for you that the claims made by the judge of the Supreme Court, who also doubles as the president of the Association of Judges and Magistrates, were nothing but calculated lies and falsehoods aimed at tarnishing my reputation, the reputation of members of the clergy, and by extension, the reputation of the Parliament of Ghana. We will defend our reputation with our last blood. Thank you.